Kaceytron is attempting a baked defense in the lawsuit involving copyright infringement, which has been filed by Ethan Klein of H3H3. So we're going to get into that today and why that will absolutely not work, no matter how high she was, and explain a little bit about copyright law. Of course, this is a legal mindset. We teach you to be your own judge. I'm Andrew Esquire, American attorney living in Asia. This is a fast facts premiere, a quick and dirty version to get out to you with the latest news. And of course, I am still on vacation. I'm in a different location. This time there's no mosquito net or ghost, if you want to say, over the bed. This time we just have a nice bathroom door. But anyways, I'm still wanting to talk to you about this because this is something absolutely crazy. And sometimes when I see things that are really, really ridiculous, when I see things that are just legally, they blow my mind. How someone can do this and just sabotage themselves in such idiocy, I have to cover it. And once again, I don't have a dog in this fight in terms of the parties. I don't care for Ethan Klein or the Hassan orbiters. I'm focused on the objective law and especially educating people on the objective law involved in this case. So first of all, let's get to Kaceytron's baked defense. Now, this is something that she came up with after she deleted, and that's a very important point, it appears she has deleted her past videos. So here she goes with an explanation that she is trying to give after it appears she has deleted her reaction video to the Ethan Klein content nuke.
Just because I didn't react to his stupid video, he had to make up that I did and put a video of me smoking weed over his stupid video to get attention. I'm sorry, I don't give a fuck about your video. Like, I don't know. I don't recall reacting to it. I don't believe that I reacted to it. I do not remember. I don't know. I may have been under the influence, but I do not recall reacting to it.
So that's once again, let's just play the important point here.
Like, I don't know. I don't recall reacting to it.
So whether or not you recall reacting to it, being the defense here, saying, I don't recall, I don't know, I may have been under the influence, I may have been baked, I may have been high. Does that work? Well, of course, I've got a nice PowerPoint to explain to you guys that, because of course that's what I do here, Legal Mindset. We educate and we entertain. So we're going to get into copyright law, and can she raise that as a defense? Well, it turns out absolutely not in this case. So copyright focuses on the act of copying and distributing work. So the focus with copyright is, did she copy or distribute work without permission, without consent, without being authorized to do so? And copyright is strict liability, which means mental state is irrelevant. You can do it, you can do it in any mental state, and it doesn't matter. It's strict liability. Did you or did you not do it? So that's one thing. Now, when it comes to damages, like once you've been found liable for this, yes, then there could be a certain amount of maliciousness that factors in there. And certainly the judge might consider that when looking at the damages portion. However, for whether or not you did it, that's strict liability. Hey, did you do it or did you not do it? You did it. Whether or not you were high and did it, or drunk and did it, or forgot that you did it because you were too tired, whatever else, that is not an excuse. And once again, it seems like they are confusing copyright, which is civil in nature, with criminal law in general. Criminal law in general tends to look more at mental state, although there are crimes that don't involve mental state. And this comes up because we see the defenders bring up entrapment, something I've thoroughly debunked already on this channel. Entrapment, something that only applies in the criminal context to police, law enforcement. It absolutely has no relevance here. Same thing with I was high, intoxication, forgetting. It's not a defense, and she can't raise that and say, hey, I didn't know I was high. But beyond that, she may be getting herself in huge trouble with spoliation of evidence. That's something, maybe it's a new word for you guys, but spoliation of evidence is intentional or negligent, which means you're doing it willfully or you're doing it recklessly without thinking. It's destruction, alteration, or hiding of any evidence that is relevant to a legal proceeding. And once a person knows that a lawsuit has been filed, they know there's something pending against them, there is a duty attached, a duty engages to preserve the evidence and not destroy it, alter it, or hide it. And if you mess up with this, if you're found guilty of evidence spoliation of evidence, there can be sanctions. There can be fines. They can have your court pleading struck, or you could have a default judgment. So Kaceytron, in picking up this defense, it appears has not only not had a defense, because this defense is not going to work, but beyond that, she may have gotten herself in trouble by potential evidence spoliation, by essentially deleting the evidence. If she's gone out and said, oh no, I'm going to try to hide this video, I'm going to try to private this video, I'm going to try to get rid of this video, now you've dug yourself in deeper, Kaceytron. And this is the point where people need to, during lawsuits, shut up and talk to their lawyer. And the problem with most content creators is they don't know how to shut up. They don't know how to just be quiet, not talk, stay off the internet, stop responding, and just let your lawyer take care of it. And that applies for a lot of the folks in this, which are continuing to comment, post on social media, rant in their chats about this lawsuit, when really they should be shutting up. They should be real quiet and saying, hey, look, can I talk to my lawyer? Can I get out of this? Because there is potential for them to fight this. There are arguments they can make. However, their lawyers are going to be put on the back foot the more they do things like this. The more Kaceytron, Denims, and Frogan decide to run their mouths and talk about this and make up stuff and make comments on this, the more it's going to put them on the back foot. But content creators cannot help themselves. They feel they have to say something on social media. They have to get on their platforms. And I would not be surprised if others have issues with this. Another area where there may be issues is involving the Reddit thread, right? The H3 Snark Reddit thread. As another lawyer mentioned, they may be subject to discovery insofar as they might have been working with Denims, Frogan, Kaceytron, and there may have been communications between them. If there are, that could be subject to discovery, which means you have to turn over all emails, text messages, etc. And if they've been deleting messages, if they've been going in and looking at their contacts between Reddit and between these content creators, and they've been deleting, hiding, or otherwise trying to maneuver them or change them, that could also bring penalties down on them as well. And I think a lot of the people involved in this just don't know anything about the legal process. They have not engaged an attorney, and they're absolutely courting for disaster. However, we're going to have to see how this plays out. I am going to be going through a full readout of the actual complaints later this week. We'll probably do it over the weekend once I get back from vacation, but I hope you guys enjoyed this. Let me know what you think about this case so far, and let me know what you think, who's going to come out on top, what's going to happen, and I will catch you on the next.